terrorism is about delegitimizing people who question the authority of the state. And that's precisely what good journalists do, is that they question things. So to keep them in jail, send a message out to the rest of the media saying that, if you report on these cases or do this type of work, we will slap you with a terrorism case. A minor was accused was convicted for murder and was sentenced to death, and it took them 23 years to prove that this person was actually a minor. The criminal justice system, the way it functions, can ruin people's lives. Encounter at Kapashera, where the judge actually said this, the lower court judge basically said this is a total fake case.
Hello and welcome to NL Interviews. I'm Akansha Kumar, and today we are joined by author and legal expert Mayur R Suresh, whose recent book, Terror Trials, Life and Law in Delhi's Courts, looks at various stages of a case as and when it is filed under the UAPA or Unlawful Activities Prevention Act, a legislation that has been hugely debated after its amended version was introduced in 2004. Mayur R Suresh is a senior lecturer at SOAS University of London and is known for his work related to anti-terror cases. He was also part of the legal team in the Nas Foundation case that successfully challenged Section 377 in the Delhi High Court and defended the same in the Supreme Court. Welcome, Professor Suresh, and thank you for agreeing to be interviewed by Newslaundry.
Thank you, Akanksha ma'am, and I'm happy to be here.
I think I'll begin first by asking that this book focuses on the cases that are filed in the lower court, and the subset chosen is that of the Tis Hazari court. Now, what made you choose and focus only on those cases at Tis Hazari court?
So I guess, the most factual way of answering the question is at the time when I did the research, most UAPA cases were being heard at Tis Hazari courts, right? So that's the reason why. And Tis Hazari courts, as you and your listeners and your viewers probably knows, has the reputation of being in one of Asia's largest courthouses. And at the time I was doing my research, it was one of 3 or 4 principal courthouses in Delhi. Obviously now there are more courthouses and judicial districts have been redone, which is why Tis Hazari court was the focus at that point of time. It also has its iconic status in the sense, where it's located next to Delhi's old city, has a kind of this history which I detail in the book of either it being the place where kind of the Sikh Empire kind of imposed a siege upon Delhi. So it has a kind of iconic status as well, and it has a big popular imagination as India's largest courthouse. All the major cases get tried there. But I guess maybe in terms of answering your question substantively, in terms of why UAPA cases, perhaps maybe that's another part of your question. I guess for me the interesting thing is, what is the UAPA? And it's not just in the contemporary moment, but also in the past with Pota, with Tada. What do these types of laws do to people? What do they do to our notions of democracy? What do they do to our notions of secularism? How do they impact on dissent? So these are the questions I think that the UAPA throws up.
I think one thing which struck a chord with me as a reader was when the book talks about the external aspect of the court itself. And to quote a line, it goes on to say, lawyers would wistfully talk about good old days when sab kuch milta tha, files and law books to alcohol and ganja. And here I think I would just like to recollect an anecdote that while working on a story in 2020 on UP's anti-conversion law, when I was outside Kanpur District Court, the visual of a man in this age of computer sitting with a board that says ki yahan halafnama tasdeeq hota hai. Does this failure to evolve explain the judicial overload in our country?
Does the failure? That's a big question to ask. So I think So I guess maybe what
I mean, you're
you
of
are
course
asking,
struck by
yeah.
the archaic nature of functioning of these courts.
Hmm.
But does this very outdated way of going about business as usual also explain the slow pace of judiciary in our country?
No, I don't think so. I mean, I don't. I, so I guess it's the judicial process is archaic in some manners, in the sense of some technology people use, typewriters, for example, that you see outside, or handwritten applications. That's one way of looking at it, right?
Hmm.
But another way of looking at it as is these different modes of accessing the justice system are ways in which ordinary people can access the justice system, right?
Hmm.
So just because they have someone has a typewriter or has kind of a board outside, is a way in which people have to interact with the law. That's a given, right? There's people have to interact with lawyers, with judges. People often have lots of problems and they have to interact with the law. Now, if we said that, everything has to be computerized, everything has to be in a certain kind of modernized in a certain way, this, in a sense, would exclude vast proportions of our population. And I don't think that would be a good thing. These kind of, I don't want to call them primitive or archaic ways, but these different modes of accessing law are important to preserve. So I think, when in Patiala House courts, if I don't know if I'm remembering this correctly, there was a move to take away the typist pool from outside. There was a big people tree. Under the people tree, there should be a big typist pool. Then I'm not sure if it's there still or not.
Hmm.
But for me, that was actually a bad thing to do, because it meant that people who had to access the justice system could not do so because they couldn't access in certain ways. It's a different question in terms of whether access is good enough. Clearly not. There should be legal aid for criminal defendants of all types. There should be public defenders of all types. There should be cheap lawyers who people can go to that are good lawyers as well. But it's so the question of technology, I don't think is answers the question of access good enough. Because for me, the question isn't the judiciary is overburdened for sure, but that's also a function of how many judges there are, what kind of support is being given to the judiciary. I mean, just look at the condition of something basic like toilets in Tisari courts or any courtroom, right? Or even just basic things like you need to make these places good places to work in for people to actually be functioning. So whether it's the infrastructure or something like that, I mean, it's a long way of saying, I think these, in the context that we have right now, these kind of older ways of doing law are important to preserve, as they provide avenues of access to justice, to the legal system, if nothing else.
Right. And also, like in the beginning, the book, while talking about the 2008 ban on Simi, that is the Students' Islamic Movement of India, refers to what the state views as quote unquote terrorist acts. And I would like to know what is your opinion about the role of Hindu nationalism, which, according to you, quote, has created a certain climate,
Mhm.
unquote. So, how do you see Hindu nationalism segueing with the very nature of such cases as well as they reach the court?
Yeah, thank you. That's a big question. So I think as a first step, it's important to understand what the word terrorism mean or doesn't mean. And I think historically, there's a new book by Joseph McQuaid that looks at the evolution of the word terrorism in colonial times in South Asia, right? And so the word terrorism was used to delegitimize any threat to its authority, any threat to the authority of the state. So whether it's writing a newspaper, putting up a poster, saying a speech, all of these things were delegitimized using the word terrorism. If you look at the definition of the word terrorism in the UAP as it stands, it's extraordinarily wide, right? It's extraordinarily wide, and that wideness means a number of people can come under its ambit, right? Whether it's speech, whether it's putting up a poster, whether it's saying something um, in public. So, for example, one of the cases brought against Simi was against Simi members, or alleged Simi members, was that they were protesting the burning of the Quran. right? So the moment you have things like that, then you're in a different terrain. You're not in the terrain of violence. You're not in the terrain of fear. You're on the terrain of suppressing dissent, right? So I think that's how the word terrorism has been used by governments, not just in India, by governments around the world in order to delegitimize democratic movements. These democratic movements might not be ones that are amenable to the state, definitely not amenable to the state. But what we see across the world in different contexts is how, whether it's Turkey, whether it's the Philippines, whether it's India, whether it's any other country, I mean, there are different kind of dimensions of this. It leads to the stigmatization of certain minority populations under the garb of terrorism. That these people are immediately terrorists, right? And so any challenge to the authority immediately becomes suspect, and in present climate, at least in different countries, immediately becomes under the garb of terrorism. That they're creating some form of violence and fear and dissent in society. So in India at the present moment, you have kind of Hindu nationalism segueing with terrorism, with what another academic chose, who worked on Catalan terrorism, Josepa Zuleika, called terrorism discourse. Like this idea of fear, this idea of that you're creating this imaginary of another person coming to attack us, or this imaginary that certain types of people are immediately terrorists, right? And this has happened in Northern Ireland, in India currently, or I mean, and you name it, and there is some element of this terrorism discourse happening around the world, especially where there's a kind of anxiety around violence or democracy. So at the present moment, at least, what's happening is that the Hindu nationalist government is saying that any dissent, whether it's in form of public protest, is seen as terrorism. The word terrorism is being used to delegitimize people who disagree with the Hindu nationalist project.
And how do you I think I'm still looking for an answer. How do you see it with respect to Hindu nationalism? Because you are talking about the ban on Simi, the case as it progressed in 2008. This is 2023. I mean, even if at that point of time you could see this strand of Hindu nationalism affecting or being playing some kind of role as far as these terror trials is concerned, what would be your observation? What has been your observation like as far as its role is concerned in the last decade? I'm talking about the period after 2014 here specifically.
September 11 attacks in 2001. There was a BJP government at the center, right? There was subsequently the bans were enacted by Congress governments, right? So there's a certain continuity between the discourse around what was happening then under Chidambaram was then the Home Minister, and what's happening now. There's a certain continuity, right? So I recall after the 2000 and I want to say the 2002 2003 ban, there was this cartoon published, I think, in the Times of India, which had one side Simi, right, and one side it had the Simi member and had had a caricature of a Bajrang Dal member saying similar, right? So Simi and similar for both. So there's a certain continuity in how the hypocrisy, pointing out of the hypocrisy of it as well. But there's a continuity between the Congress governments before 2014 and the BJP government at the moment. I think what you see, for example, many Simi members, alleged Simi members, were prosecuted by various Congress governments at the time. So there's a kind of continuity. At the same time, there's a distinct way in which the UAP is being used now. For example, the ability of the central government to designate individuals as terrorists, that is something that's come up now. Without a court process. There's its own administrative process, but the government can designate designate people as terrorists without going through a court process. The way it's been used in dissent cases, for example, whether it's the anti-CAA protests in Delhi, or for example, this whole conspiracy around the Bhima Koregaon case. There are ways in which the UAP is being used to target especially people who are dissenting against this Hindu nationalist project. And I think that is probably more sharper now than it was before, simply because of who the government is at the moment, or what parties are in the central government. So I think that is probably what's different from 2014 onwards.
Right. And also, in one of the chapters that looks at the interaction between the police and the accused, there is an anecdote about two brothers, Nadeem and Fahim.
Mhm. Mhm.
And they happen to be informers for the special cell of Delhi police, but then they are implicated by Maharashtra ATS in another case related to 2611. Uh, and these two brothers, they are caught in between this some kind of tussle between two premier investigation agencies of our country. Do you think that there has to be some kind of framework within the law, UAPA itself, that ensures accountability of these investigation agencies?
So I think the one thing that if and I don't think is the case, but I think if the government was definite about providing for accountability, then remove the immunity provided in the CRPC, in the ordinary law. So under the ordinary law, you can't prosecute. It's very difficult, rather, to prosecute people for, especially police officers, for fabricating evidence for malicious prosecution. You need prior government sanction. So forget the UAPA. Just go to the basic law, right? And one way of ensuring accountability is to remove immunity, right, or impunity, right? So whether it's the AFSPA or the CRPC, remove the immunity. If the police officers or police agencies are so confident of their cases, let them stand up in court, right? So, for example, in one case, this is regarding the encounter at Kapashera, where the judge actually said this. The lower court judge basically said this is a total fake case. The police ought to be prosecuted for for malicious prosecution, for fabricating evidence, for contempt of court, basically prejudicing the course of the investigation, the trial. If the state was so keen on accountability, which of course they're not, why did they appeal that particular judgment, right? If they, so it's not even about the UAPA anymore. I mean, UAPA is a problem, right? But something as basic as removing immunity is something that needs to be, if and I don't anticipate this happening anytime soon, but something that, if you're keen on keen on ensuring the authenticity and robustness of your case, don't be scared.
And
Remove your immunity.
so
Yeah.
isn't that like a gray area, which is part of the law? And here, of course, we are not talking specifically about UAPA, because a lot of the FIRs that the police files, they are
Mhm.
based on that they got information from a mukhbir. They refer
Yeah.
to informers, they are never named.
Mm.
And
Mhm.
the general belief and tendency among lawyers who, practice law on a daily basis is that you cannot really ask police about the mukhbir in detail, even as the trial
Mm.
progresses. So, isn't that a sort of gray area in the law itself which needs to be corrected for greater accountability?
Yeah, and so my thing is this. So the argument for these exceptional measures, right, whether it's this not naming the mukbir or having people in jail for longer pending bail or having very strict bail conditions in the UAPA,
Hmm.
is that, it's so difficult to prosecute these cases, that we need special rules, right? But actually, it should be the opposite. These cases are so high intensity, such pressure on these cases, you need greater scrutiny of these cases. You need greater scrutiny of how the police functions, right? So in these cases, which are serious cases, I'm not saying they're not serious. If you're alleging that some person has put a bomb in a marketplace, of course it's serious. But the fact that it's such a serious case means you need more accountability and more scrutiny,
Hmm.
right? So it's the logic. We need special rules to help us prosecute these cases. For me, it should be the opposite. You need more scrutiny of your cases, because the temptation of police officers, of even of the lower judiciary, to give people leeway in these difficult cases is something that's very real, and I understand that. But it's precisely because of that human nature that we want to solve this case, we want to get the culprits of these heinous crimes arrested, that you, in a properly functioning judicial system, in one that's founded on a belief of innocence, that you have to have higher scrutiny. And I think that's the case. It's not lower scrutiny, it's higher scrutiny.
And when we talk about some of the recent high profile cases filed under UAPA, one of which is the 2018 Bhima Koregaon case involving as many as 16 activists. Now, as of March 2023, the trial is yet to begin in the case. What do you have to say about the normalization of such an exceptional law in India?
Yeah. I mean, so at one level, it's endemic to the Indian judicial system, right? So, for example, yesterday, Project 39A at NLUD, they put out, they had this case where a minor, I'm probably get the details wrong, a minor was accused was convicted for murder and was sentenced to death. And it took them 23 years to prove that this person was actually a minor. Right. So at one level, it's this person has spent 23 years from the age, I think, of 13 or 14 onwards, 23 years, most of that time on death row. And it took them that long to prove that he was a minor, right? He should not have been tried as an adult, right? So that at one level, it's that, right? So, but what the UAPA does is it institutionalizes this delay, right? At one level, for the case that Project 39A talked about, you can talk about delay of appeal, delay of whatever. That's this thing. That is a horrible thing to happen. But what happens in the UAPA is it institutionalizes it, right? So it takes the worst, the kind of the most problematic aspects of the Indian judicial criminal justice system and puts it into law. The delayed bail, the unavailability of, for example, of challenging certain types of witnesses, right? So this or the admissibility of certain types of evidence, right? It takes the worst aspects of the Indian judicial system and puts it into law. So, for example, the delay you're mentioning is very common in UAPA cases. It's institutionalized because the police have such a long time to frame their cases, to make their cases. The fact that it makes bail impossible, right? It forces people to stay in jail as long as possible. It ruins people's lives, and that's part of the aim of it, right? Gautam Navlakha, who's who's one of the accused in the Bhima Koregaon case, wrote an essay about this in the EPW, basically talking about how these anti-terror laws institutionalize this delay, right? Institutionalize the fact, makes the process the punishment.
And like you mentioned earlier, that you see it as a continuity between the UPA and the NDA government as far as enforcing this law is concerned and acting like a state which views some of its subjects with suspicion. When this, again, with respect to Bhima Koregaon case, which has been in news, do you see a trend there as well in terms of targeting certain section of people, in this case activists, because this government does have a view on those who have been working as grassroots level activists or workers? Do you think that also may have played a role as far as such high profile cases are concerned?
Yeah. So that's a good question because, I mean, at one level, you're describing the government on top as a certain way, right? But at another level, this is by the local police also, right? And so the question then is so if I say it's the government doing it, the central government that's doing it, then the implication is the central government is sending orders down, which is not the case. I mean, I don't know if it's the case, who knows, right? But I don't think it's the case. Let me put it that way. But what the UAPA does, or what this anti-terror law does, is it authorizes local actors, local police, local kind of right-wing activists to act in the name as if they are acting in the name of the central government, right? So it authorizes forms of impunity at the lower level, and that's what I think is happening over here. People say, "Oh, someone is protesting against the CAA." NRC, and therefore they look at them. They're of a certain religion. They're of a Muslim minority. They must be terrorists. Let's put a terrorism case on them, right? So this idea of this kind of terrorism discourse filtering from the top down is something that's very real, I think. So I don't think I don't think it's the case that the powers that be at the top are sending orders down. Maybe it's the case, maybe it's not. I don't know, but it's definitely the case that at the lower levels, people are kind of imbibing this discourse that certain people, certain types of people are. You can call them terrorists and get away with it, right? Or you can name them as terrorists and get away with it because the process of the UAPA allows for such types of impunity and immunity. Right. So it's and I think that's probably what's happening over here. This kind of filtering down of this form of discourse for certain types of people, whether it's dissent, whether it's certain Muslim communities or certain other communities are labeled as terrorists, and that's what's happening in a sense.
Like there's one more question again related to Bhima Koregaon case only, that this particular case made it to headlines also because of some of the most dehumanized responses by the state machinery. Be it denying a sipper to 84-year-old Stan Swami, or saying no to Gautam Navlakha for having his glasses replaced. What do such gestures tell you? I mean, do they also confirm one's view of the arbitrariness of the quote-unquote trial without a trial?
Yeah. At one level, it's definitely that, right? It's one level that, we're not going to be. So, I mean, I think in theory that, we have the great idea that everyone's innocent and proven guilty, that every person, regardless of what they've done, is entitled to some form of dignity. And that's a value that I hold, but clearly not the powers that be and the local bureaucracy does not hold it, right? So, I think at one level it's that, but at another level is just this idea of authority and authoritarianism tendencies, not just at the top, but at the bottom level, right? It's because it's such a cruel thing to deny someone a straw or a chappal or their glasses. It's patently cruel, right? But it also shows a form of I am going to show you my authority by doing something so petty, right? And it's not something that just that happens in India. So there's this um, there's a diary called Guantanamo Diary by this guy called Mohammadu Ul Slahi. I'm probably mispronouncing his name. Of his time in Guantanamo Bay, right? And so they would obviously there was horrible torture, and that was there, but also small things. Oh, today we're going to take away your TV rights. Oh, you want cold water? I'm only going to give you hot water. I mean, things like that, small things like this that I don't think he writes about, but it's in his. I think I've read it somewhere about him. But small moments of inhumanity, right? And I think that form of authority that I as a small petty officer can take out can use my authority on you, right, is something that's definitely in society and in different forms of state and different forms of at different levels of the Indian government. So I think is even more worrying because you have these authoritarian tendencies not just at the top but in all levels of authority of the Indian state, which is slightly disconcerting, which is very disconcerting.
And I think another section which has faced cases under UAPA is that of journalists. And we recently have this case of Kashmir journalist Irfan Mehraj, who has been arrested under UAPA. A few months ago, it was Jharkhand-based journalist Rupesh Singh. Of course, Kerala-based journalist Siddiq Kapan was also slapped with a case under UAP, and he recently came out of jail. How do you view this antagonistic relationship between the state and journalists, which is essentially seen as an attempt to gag media?
So it's a censorship by stealth, right? So what does the word terrorism do? The word terrorism delegitimizes you, right? It says that you aren't an honest actor. You aren't a person. You aren't what you seem you are. This whole idea of terrorism discourse is basically that they aren't what they seem, right? So the idea of terrorism that anyone could be a terrorist, that terrorists are everywhere, and we're under the state of siege, right? It could be me, it could be you, it could be the next person. Anyone can be holding a bomb or a gun or something. We don't know. right? So this idea that anyone could be of particular types of people can be a terrorist is something that kind of is filters down, for example, into in how in these cases that you mentioned, that these people aren't actually terrorists. One is running an NGO funding case. The other person has come here to kind of highlight, to foment communal violence or show how certain people are of a certain type. So I think what's happening is that it's censorship by stealth. It's the use of the word of terrorism to delegitimize what important work these journalists are doing, right? And in a sense, these journalists are being targeted because they are bringing to light certain cases, certain disturbing things that are happening in our country, and that's why they're being targeted. But the use of terrorism laws is simultaneously to delegitimize them and to keep them in jail for as long as possible. Because if you're in jail, what do you want to report about? I mean, you can report, I guess, about the jail conditions, but effectively you can't do anything. So to keep them in jail, send a message out to the rest of the media saying that, if you report on these cases or do this type of work, we will slap you with a terrorism case.
And at a certain level, do you also see it as a professional hazard that, we as reporters and journalists are into crosshairs with different probe agencies, and there is a chance that we may emerge as subject of suspicion while a reportage? Because in case of Siddiq Kapan, uh, of course, the Supreme Court questioned the UP police that you don't really have a basis. And yet, because he was on his way to Hathras with a group of, members from the Popular Front of India, which has now been banned by the center, but back then also it was viewed with a lot of suspicion by the UP government, which had held the outfit responsible for violence in during anti-CA protests in 2020. So do you think that it could also be an instance of professional hazard where you can be caught in a trap of sorts?
Yeah, I mean, for sure. Like I said, so terrorism has never been about um, actually preventing people from violence, right? Incidentally, let's say, is that right? Like I said at the beginning, terrorism is about delegitimizing people who question the authority of the state, right? And that's precisely what good journalists do, is that they question things. They don't take what the state says as the gospel truth, right? And so if you're a serious journalist and you're going to question the state, and it could be even a minor question, like is this like questions about, it's not a minor question, but questions about this particular horrific rape, what is the police role in that? It could be questions like that, basic questions. But the moment you do something like that, you're seen as objecting to the authority of the state, right? And in a state that's so paranoid and it's so kind of nervous about its own authority, questions like this are seen as threatening to its authority, right? So the labeling of journalists as terrorism is, as you say, is probably a professional hazard, because good journalists always question people, whether it's a state, whether someone else. But the fact that you're questioning the state is something that challenges its authority, feels nervous about that, and that's why terrorism is being used as a cover to prosecute these journalists.
And like a characteristic feature of cases filed under UAPA, which, like most other cases as part of criminal jurisprudence, rests heavily on speculation by the investigation agencies. And they try to justify their own apprehensions or beliefs in the form of voluminous charge sheets. Now, in the case of Siddiq Kapan, for instance, the UPSTF filed a 5,000 page charge sheet, and there were daily diary notes that spoke at length about his reportage focusing on minorities. Now, does that seem problematic to you?
Yeah, it's basically performance, right? The UP government is saying, "Oh, look, we have 5,000 pages of documents. There must be something here." Because by the time someone reads these 5,000 pages, who can read 5,000 pages? Like if you're brought before a magistrate, or even 6 months later when you're finally charged, if you're ever charged, who can read these 5,000 pages, right? And so these 5,000 pages, I mean, can be, who knows what's in them, but it's basically, it's a performance that has very real consequences, right? They're almost using these files as props to say that, look, we have such a big stack, there must be something here.
So, of course, you answered the first part that it is all about performance when they are filing such voluminous charge sheets. But the fact that, the investigation agencies and even the lowest level SHO and IO also has a mindset which is reflected in these daily diary notes. Do they also kind of convey a certain message?
Yeah, like I said, I don't think, like I said before, I think what maybe it's new, maybe it's old, I don't know, but this idea that any form of challenge is, in a sense, kind of problematic, right, for the state, for whether it's the highest level or the lowest level, the SHO level, there is any form of a challenging what your narrative is problematic for them. And so obviously, I mean, I can't impute motives to the police, but from what I've read on the newspapers, it seems as if there was obvious anxiety around this Hathras gang rape and murder. And they didn't want that anxiety exacerbated. And they didn't want any media attention on it. The fact that he was allegedly going with some PF5 people is probably gave them additional material to prosecute him. But I mean, this is constant. So how kind of these terrorism cases often work is who you know and who you're involved with, right? So just because in the case that you mentioned earlier, Nadeem and Fahim, in their narrative at least, the only reason why they were arrested was because they knew someone who or they had one social or two social interaction with someone the police claim was a terrorist, right? And so people can come into, or that someone else, that your relative or something, so it's almost like it's like terrorism by family tree almost. Just because I'm related to someone doesn't mean that I become a terrorist. And it's the nature of these FIRs and the way things is what Vrinda Gova, famous lawyer, calls omnibus FIRs. You name everyone. There's an unknown conspiracy, and in certain cases used to delegitimize the prosecution. For example, in riot cases, you name 70 unknown people and you can't prosecute anyone, right? But in terrorism cases, these omnibus FIRs, these 70 unknown people, becomes a way of expanding the case entirely.
One particular provision of UAPA that has been debated quite a lot is Section 43D5, which makes it getting bail really difficult. And of course, Stan Swamy, days before his death, had challenged the provision. But it is another judgment, the 2019 Vatali judgment, which is quoted quite often, and in which the court basically said that prima facie, if there is a case, then they will not really grant bail or look into the intricacies in terms of evidence. They would look into the totality of the case. Would this debate about infringement of one's fundamental right in terms of accessing bail, do you think it would be settled by the judiciary or the executive when we are talking with respect to Section 43D5?
I mean, I think it's unsatisfactory with the Vatali judgment. It's kind of unsatisfactorily settled by the courts. But I guess, I mean, is the court, I mean, I don't think there's any, so my thing is, I don't think there's any way in which the courts will go back on that. We've seen kind of recent judgment overturning a previous judgment on membership. But I mean, the fact that, so I guess the problem with how 43D5 is that if there's a prima facie case, you would have been charged, because that's the threshold for charging someone, right? But bail is supposed to be different. Bail, you're supposed to be out on bail if for example, you're not going to prejudice the course of the case. You're not going to interfere in witnesses. You're not going to commit more offenses. You're not going to run away, right? And that's usually the standard for bail, because you don't want to keep people. The premise is people are innocent till they're proven guilty. You don't want to keep people in incarceration, right? For long periods of time, because we know that the criminal justice system can, the way it functions, can ruin people's lives, and you don't want to do that unnecessarily, right? That's at least the principle behind it. But the fact that you've raised the threshold for bail to say that you, if there's a prima facie case against you, then you are denied bail. That for me mixes up two processes in the criminal justice system. One is charge and one is bail, right? So this kind of muddling of these two is deliberate in the UAPA, and that deliberateness has been given a stamp of authority by the court. So I'm not sure where there's any hope at the moment.
And
Yeah.
finally, what would be your take on the recent observation of the Supreme Court that came just days ago, in which it has overruled its earlier ruling, wherein it was first said that mere association with a banned organization will not incriminate a person, but the Supreme Court has overturned this ruling. Now, in most such cases, the association part, when it comes to the investigation agency, it's usually established with the help of recovery of some literature. Do you think that the court has actually narrowed down the purview of who will be the culprit in such cases?
In fact, I think it's expanded the purview of who's going to be a culprit, right? So I think maybe I've misunderstood your question, but I think what they say is, so the earlier judgment was, if you're, so let's say I'm hypothetically a member of association A, right? I just pay the membership fees, or once upon a time I will remember, I keep on getting the magazines, let's say, who knows, right? Now that association is banned. What Markandeya Kaju judgment before, and Aru Bhuyan, I think was the case, right? Basically said that there has to be a higher threshold for you to be prosecuted for membership, right? What this case then is lowers the threshold. Just by mere association with that particular organization, I can be prosecuted for membership of a banned organization or terrorist organization, right? So it much lowers the threshold, which means that the net is much wider. So, for example, if I had to, and there's no statistical backing for this statement I'm going to make, but if I had to hazard a guess, most cases under the UAPA are for speech cases and membership cases. I would say a minority of cases are for acts of violence, right? So and again, just speaking anecdotally, as you said, most people, how do they show membership of a banned organization? It's some literature,
Yeah.
right? They're in possession. So if that's the threshold for if mere membership is an offense, and if the threshold for proving that mere membership is possessing literature, then any number of people can be arrested for possessing literature, right? Because all of these organizations produce literature. Because at the end of the day, they're campaign organizations. They're doing something, they're advocating for something. Whether we like it or not is a different question. But just mere possession of literature should not indicate mere membership. And mere membership without something else, without doing something violent or doing something else, is just basically expands the number of people who can be arrested for terrorism cases under the UAPA. So that's what it does. It lowers the threshold. It makes it so eventually people may be acquitted. And I think the terrorism statistics are varied, but I would say the conviction rate is very low. But that's not the question with UAPA cases, because you can be in jail for 10, 14, 20 years, right? While your case goes through the courts and finally be acquitted. So you'll be in jail for just possessing a pamphlet that some organization wrote.
And I think I'll conclude by quoting an excerpt from an editorial that came out today in the Indian Express by former journalist Ashish Khetan, someone whom I used to admire a lot before I came into journalism. And he has been very critical about this recent observation, And he goes on to write, banned organizations are not known to keep a registry with their members' names, addresses, phone numbers, and email IDs. Even in the case of a lawful entity with records of membership, how will any agency or court conclude who is and continues to be a member of such an association even after the entity was banned? So
Absolutely.
I think the debate on the law itself and even such observations by the court will continue. And I think you and I will have more such brainstorming sessions to make sense of this legislation. Professor Suresh, thank you so much for speaking to News Laundry.
Thank you for having me.